crypto, the notion that SEC Chairman Gary Gensler is quitting has swept Twitter. John Deaton, an attorney who is in favor of XRP, the legal squabble between the Securities and Exchange Commission, SEC of the United States, and Ripple Labs has piqued the interest of the cryptocurrency community. With the SEC recently launching an interlocutory appeal, there's been a lot of debate over whether the XRP coin is a security. On August 9, the SEC addressed Judge Annalisa Torres, indicating its desire to reconsider the court's decision. During the appeals process, the regulatory authority requested a temporary stop to the case. This decision raised various issues, most notably concerning the SEC's intentions regarding XRP's non-security classification. Nonetheless, members of the legal crypto community have attempted to allay any fear. According to crypto lawyer Jeremy Hogan, the SEC's appeal and XRP security classification are separate issues. A successful SEC appeal, according to Hogan, would prevent Ripple from enabling sales on exchanges. However, he noted that this does not exclude other exchanges from offering XRP as long as Ripple is not the seller. Cointelegraph spoke with Oscar Franklin Tan, Chief Legal Officer of the non-fungible token, NFT, platform engine, to help decipher some of the complexity of the SEC's decision. He clarified the nature of interlocutory appeals, which are often sought before the completion of a case. Tan demonstrated the importance of momentum in such appeals. If the appeal is successful, the prevailing side will acquire an advantage in the original lawsuit. While Hogan believes the appeal will not question XRP's non-security status and believes otherwise, he believes the SEC is still trying to overturn Judge Torres' prior decision, which declared XRP a non-security under certain instances, and shed information on the SEC's tactics by using the Terraform Labs case conclusion as leverage against the court in the Ripple case. He speculated that the SEC is implying that a higher court should intervene to reconcile different rulings. Tan's viewpoint, however, remained critical of the SEC's actions. Instead of racing to court, he believes the SEC should have issued clearer instructions, and feels that with Ripple and other organizations seeking clarification from the courts, the usual legal procedures should proceed without intervention. In the midst of these legal swayings, Ripple's chief legal officer, Stuart Alderoty, has warned the community to be on the lookout for Ripple's impending judicial response. Predictions and guesses are widespread in the quickly growing world of cryptocurrency. However, when a famous individual like Ripple's CEO, Brad Garlinghouse, makes a remark, the crypto world stands up and takes note. Garlinghouse has said that XRP is in the same category as Bitcoin, even going so far as to say that XRP is the next Bitcoin. In delving further into his XRP vision, Garlinghouse established a grandiose target price of $10,000 for the digital currency. To many, such a number may seem implausible, particularly in light of market capitalization and the massive amount of money that would need to flow into XRP to attain this goal. However, the Ripple CEO soon responded, claiming that market capitalization has no influence on the value of a currency. This remark goes against popular thinking and initiates an intriguing discussion about the measures we use to evaluate cryptocurrencies. Garlinghouse's upbeat outlook on XRP may not surprise those acquainted with the digital currency's path and Ripple's larger goals. Ripple has continuously underlined the significance of cross-border transactions, remittances, and global payment infrastructures, all of which might benefit from the use of XRP. In addition, the business has created agreements with various financial institutions across the globe to demonstrate the usability and real-world application of XRP. Garlinghouse isn't only hyping the price appreciation potential of XRP as a Bitcoin replacement. Instead, he's implying that XRP's usefulness and acceptance might match, if not exceed, Bitcoin's. It is a future in which XRP is not simply another cryptocurrency, but is firmly ingrained in the world's financial institutions and processes. A fresh thread has been weaved into the complicated tapestry of the legal dispute between the U.S. Securities and Exchange Commission, SEC, and Ripple Labs. Judge Annalisa Torres has granted her approval for the addition of an investment banker declarant, a move that had previously been met with opposition by Ripple owing to the law firm's involvement with the SEC. Andrew A. Kunsak, representing the prominent legal firm Sidley Austin LP, has been authorized to participate in the SEC's against Ripple Labs litigation. According to the court document, Kunsak's input is designed to guarantee that no secret facts get out, in accordance with an earlier court order that had sealed some material. This is specifically linked to the SEC's motion about the Hyman speech documents and Ripple's motion regarding its revenue information from XRP sale. Given the complexity of blockchain in the crypto world, such cases often go into areas where critical corporate or shareholder information may be jeopardized. The court's action seems to be a precautionary effort to protect such data, particularly given the SEC's determination to challenge a recent decision by Judge Torres. In a noteworthy turn of events, the SEC has filed a move for an interlocutory appeal. Their complaint is directed at Judge Torres' decision, which stated that XR programmatic sales are not securities under the legendary Howey test. This is a crucial difference in the realm of cryptocurrencies, outlining the thin line between conventional digital assets and those that may be regarded as investment contracts, with the latter subject to stricter laws. As the legal drama unfolds, Ripple's chief legal officer, Stuart Alderodi, said that the SEC's current goal is to get a court order to file an appeal. Contrary to popular belief, they are not explicitly appealing the decision on XRP's appealing the decision on XRP's classification as a security. An important court judgment was issued in July, and the U.S. Securities and Exchange Commission, SEC, has taken a major step forward by filing an appeal. The SEC's legal battle with Ripple Labs resulted in this historic judgment, which held that the sale of XRP to ordinary investors did not constitute the offering of a security. This new information was sent to the sitting judge, Anlesa Torres, in a letter just yesterday. Apparently, the SEC believes that the significance of her ruling requires a further review by an appeal court. According to the SEC submission, interlocutory review is needed here. The intra-district gap that has already emerged shows that these two problems concern controlling matters of law on which there is significant room for differences of opinion. The SEC wants to have the court's ruling certified that the defendants' programmatic offers and sales of XRP to purchasers on crypto asset trading platforms and Ripple's other distributions in compensation for labor and services did not entail the offer or sale of securities under the federal securities law. The Honorable Judge Anlesa had laid out her plans in great detail behind the walls of the U.S. Southern District Court. As part of these preparations, a trial was set aside specifically for investigating novel concerns that had not been addressed in the preceding arguments for summary judgment. The second quarter of 2024 has been tentatively chosen as the time frame for this study. The SEC has provided a detailed schedule in its official filing that will be used to guide it through the complex proceedings. A week after the submission of the aforementioned letter, on August 16, 2023, Ripple will have to respond. The next stages, which the SEC says should be carefully orchestrated, will be as follows. The 18th of August will see the filing of an opening brief explaining the rationale for the appeal. As a result, Ripple will need to come up with a response in the next 2 weeks. If the court approves of this well-choreographed legal pass to Troy, the SEC, which is at the head of this legal dance, will respond in kind within a week. Crucially, the scope of the U.S. SEC's appeal has been clearly defined. The agency's challenge to XRP's designation as a security is narrower and more sophisticated than the larger objection that has been raised thus far. In particular, the government is appealing the ramifications of the token's programmatic and individual sales, but not the larger categorization judgment. Since the SEC does not yet have the right to appeal, it is requesting leave to initiate an interlocutory appeal. Next week, Ripple will submit a response to the court.